Oh, hello. I'm Jamie Gorton. I'm the lead attorney at Gorton Law in Malden, and you may be wondering why I'm about to start drinking red wine from a solo cup in the middle of my office. Well, it's because I went to Google and I entered the phrase USCIS quarterly all forms and looked at the entries for the I-601A waiver. So today's YouTube video is going to be about what we found there, what the delays are with the I-601A waiver, and what, if anything, can be done about it. So we're Gorton Law. We're located in Malden, Massachusetts. We help employers hire and retain world-class talent. We help families unite legally under the immigration laws, and we do a lot of I-601A waivers of inadmissibility. So this is something that definitely affects my practice, my business, and most importantly, our clients. So before we get started, as always, we have a sponsor for today's show, and today's sponsor is HEPA filters. HEPA filters. Have they saved me from COVID? I'll never know. But man, with this many printers and reams of paper in an immigration lawyer's office, the amount of dust is absolutely fantastic. So ask your immigration lawyer if they are running HEPA filters. So what is the USCS quarterly all forms Google phrase going to pull up for you? It'll bring up the quarterly report, this one dating back to March of 2022, as to how the USCIS is doing in terms of cases in, cases out, cases in backlog, and pending processing times. And the I-601A waiver numbers are frankly just as shocking and dismaying as any other number on the chart, but this is a major barrier between people who are in relationships with U.S. citizens or are the children of U.S. citizens that stands between them and getting a green card. So it is absolutely worth a very close look. So in the second quarter, immigration brought in 9,500-ish applications for the I-601A waiver. They adjudicated, how many do you think? They brought in 9,500. Do you think they did half? Do you think they did a quarter? They did about 1,800. They did 1,800 applications, resulting in a backlog of 106,000 cases waiting for adjudication. The current processing time is 28 months. In other words, every 3 months, immigration gets 15 months worth of I-601A waivers. I have enough to share. So, with this processing time in mind, why you have to just look up to the skies and ask why is this going on? So let's take a little trip, and this is now pure speculation, so I am going to have to just look in my crystal ball and make some guesses. March 2020, a lot is going on. Number one is COVID. Number two is that the Trump administration is on its ongoing and almost monomaniacal focus on the southern border. As a result, it is easy for one immigration lawyer to imagine that something came down from the powers that be on high that went like this. The I-601A waiver is only used by people who need to leave the United States and to get their visa at a consulate overseas. All of the consulates are closed. All of the flights are grounded. No one is going to these interviews. Therefore, you don't need to be working on I-601A waivers right now. You go work on, again, in theory, literally anything else. But in particular, one imagines that maybe some resources were, again, reallocated to focus on the southern border. So I have no idea, just a guess, but it has, I think, a plausible shot of being what's going on behind the scenes, because if you have an application type that is just not urgent, immigration is not going to light a fire under themselves to solve it. I mean, this is not, it's USCIS, which is a major government bureaucracy. It is not a tech startup that's trying to ship the product out the door the moment it's ready to be downloaded. It's a bureaucracy that works on paper and 40-year-old computer systems. And it doesn't need the help being slow. But if you start to reallocate resources away from something like an I-601A waiver, that's what you're going to get. And my guess is not just a guess, it is an educated guess, because this is what they do with I-130s. If you file an I-130 for the spouse of a US citizen, it will go through on one processing time. If you file the I-130 for the sibling of a US citizen, it's easy for immigration to look at that and be like, they don't need an answer on this for the next 14 years because that's how bad the backlog is for visa numbers. So we will get to this when it's, time for us to get to it. So USCIS is known to sort of allocate resources in certain ways, and that's why I'm making a prediction as to what might have been going on behind the scenes. So I'm guessing about the why, but I'm not guessing about the numbers. Like I said, if you ever feel like you want to have a stiff adult beverage in the middle of the day, go Google the USCIS quarterly all forms report, and it will send shivers down your spine. Another major factor that we're aware of is that immigration is at approximately 80% staffing as of the time this report came out. This is according to USCIS head Urjadu, who came to the AILA National Conference in New York and presented to the immigration lawyers present about their problems hiring. And it's not just that labor is tight everywhere in the United States, it's also that this is a government bureaucracy. And it is not easy to hire into these positions. It's not easy to train them. The area of the law is complex enough that it's a full-time day job for lawyers like me. So when you're down 80%, you just don't have that pool of people available to go and sit at this computer and do this set of cases. Even if they did, the third factor is that USCIS is prioritizing other things. They have come out with their new policies for time standards. They say they want most everything to be done in about 6 months, which is a jolly aspiration. Like, I also would love that, among other things, like a new Buick in my driveway. Do they even make Buicks anymore? I don't know. Yes. Okay, we'll check that one offline. But regardless of my dream car landing in my driveway, I just would love to see immigration get to 6 months across all of its case types. The reality is that some cases are more equal than others. In particular, people who are waiting for their work authorization are going to be extremely vocal about not having it when they need it. And of course, if you're taking over 8 months to get someone a work authorization, that's a long time for a spouse of a US citizen to be hanging out in the basement and unable to work or contribute to the economy. A huge number of workers and a huge amount of human power in the United States economy is locked up behind USCIS's inability to get work permits. And again, this is not something that had to be this way. This was some choices that were made by the Trump administration, and they did a almost just genius job of figuring out how to shut down the prompt issuance of work permits. So something that not that long ago took 3 months now takes 8. Immigration is going to want to make sure that that problem is resolved and that naturalization applications are running smoothly, because those are a very high priority, and that adjustment applications for immediate relatives have to run very quickly and very smoothly. And there are companies that are paying premium processing fees to get decisions in 14 business days, and that has to run smoothly and efficiently. And there's always going to be something else for immigration to be working on. The I-601As, apparently, I don't think that they feel very urgent to USCIS these days. So what is there to be done? As always, we do have to counsel patients for people who need this. People who need this type of waiver are typically people who have been in the United States for a while, and they've typically been working on their immigration case for a while. And that's why it's so disappointing and so frustrating for the clients, but also for the attorney to feel a little powerless when you mail off an application and you have to say, well, we've done our work, you've done your work. Now it's on the government to make a decision, and they might make a decision, in a little over 2 years from now. The wait for people who benefit from the I-601A application has already been long enough. Of course, if immigration is going to say this is what it is, right? And they're going to say, we're being honest. We're doing $1,800 a quarter, and we can't control the number that we take in. You do wonder, one wonders where all the money from those $715 application fees each go, but it's clearly not to adjudicating these particular cases. So that leaves you with not a lot of options. Sooner or later, enough time will go by where you may be able to sue the government for an unreasonable delay, which also probably deserves its own video topic. But until your case has been sitting on a shelf for over 2 years, you really don't have an argument that the case has been going too long, because immigration will just say that, you're in line with everyone else, and we make decisions based on the receipt date of applications, and we don't let people jump the line, and we typically do not feel like we should be expediting any of these particular cases. So that was the distressing news of the afternoon, and yet somehow I'll check that report again next quarter and probably feel the same way, and we'll let you know. As the ancient Chinese proverb says, the best time to file an I-601A waiver was 28 months ago, but the second best time to do so is today. Here at Gorton Law, we pride ourselves in our ability to do smart, well-crafted, and meaningful I-601A applications. Unlike a marriage-based application, or unlike a work permit, or unlike a lot of employment-based subjects, the I-601A waiver is you telling a story about your life and your family to an immigration officer. And you have to use the language of immigration to do it, and you have to match it up with the factors that they use to make decisions on cases. And that's why having an experienced immigration lawyer who has done these waivers before is absolutely essential. I cannot urge strongly enough that if you are going to be needing an I-601A waiver to complete your immigration journey into the United States, you should really be working with an immigration attorney. These are not for people to try at home. These are very complex, and they require you to really nail a certain type of sales pitch over into the immigration officer. And even if you think you don't qualify because you've heard that it's about something called extreme hardship, and that sounds like unfamiliar to your life because you think your life is going great, still have a consultation with an experienced attorney, because a lot of times it's just a matter of having someone ask you the right questions and learn the right answers in order to figure out how to best tell that story to USCIS. So our attorneys here in Malden, Massachusetts, will always be willing to serve people who need I-601A waivers, whether you're in Boston, whether you're in Massachusetts or New Hampshire, whether you're anywhere in these United States. So thank you very much for your time with the YouTube. Remember, do not drink in your lawyer's office. And until next time, let's all cross our fingers and hope that we can get these processing times under control with USCIS.